Hello, I'm Walker Kahn. I'll be sharing my research on mortgage foreclosure and financialization. And you'll have to forgive me. It's a terribly Americanist presentation, but we'll just all, sally forth and do our best. Okay, so between 2007 and 2012, 12.5 million homes enter foreclosure in the United States. The scale of human tragedy is difficult to comprehend. It's something like 2 Hurricane Katrinas a year for 5 years. Homeowners who entered foreclosure lost $7 trillion in housing wealth. Their neighbors lost more than $2 trillion. But foreclosure is, of course, more than just an economic problem. It reduces health outcomes for individuals and communities. It increases suicide rates. Forced residential displacement is associated with worse performance in school among children and adolescents and increased exhibition of violent behavior. So foreclosure is a big deal. And we are still struggling to understand the 2007 crisis. We're struggling to understand, how did this happen? And here, I'm not referring so much to Wall Street bets or unrecognized risks or complex derivatives. I mean, how did foreclosure occur on this scale? 12 million foreclosures is not something that just court systems and mortgage markets have to develop the institutional capacity to process this tidal wave of foreclosure. Judges need to be willing and able to hear these cases. Markets need to be organized in such a way that foreclosing on 12 million homeowners is both operationally feasible and a reasonable business decision. How does this happen? The sociological literature broadly agrees that the foreclosure crisis was caused by or related to financialization. Financialization is the growing power of financial markets, actors, ideas, and all aspects of society. And this is pioneered by Greta Krippner and a group of other scholars. Common answers point to governments relying on markets to make hard decisions about distribution, flawed evaluation practices in the financial industry, and the internal organization of governance and financial firms. We've never asked how financialization made mass foreclosure possible, how it changed the legal and economic systems that structure foreclosure, and how it directly changed the foreclosure process itself. My research question is, how did financialization change foreclosure? And notably, if you talk to judges or housing advocates, they'll tell you that the foreclosure crisis didn't start in 2007. The foreclosure crisis began in the early 2000s or the late 90s, when households headed by women or people of color began to experience rates of foreclosure as high or higher than white male-headed households experienced between 2007 and 2012. To understand how the institutional capacities necessary for mass foreclosure developed, I'm going to look at the years preceding the 2007 crisis. Today, we're going to examine how financialization changed foreclosure and made mass foreclosure possible. We're going to do this by tracing specific mechanisms of financialization, mortgage securitization, and court fees to changes in the foreclosure process. We'll discuss the implications of these findings, and then I'll take questions at the end. So this just to preview my findings to give you guys a roadmap of where we're going. Financialization through the technology of mortgage securitization takes us from locally embedded mortgage markets and locally embedded mortgage lending to international markets and mortgage-backed securities. Securitization severs ongoing relationships between lenders and borrowers and disembeds lending from local communities. It also fragments the mortgage industry into a series of niche markets where actors profit from a specific single node on the value chain rather than the entire life of the loan. Specialized asset managers called loan servicers, mortgage servicers, manage foreclosure but don't own the loans. These actors can profit if foreclosure is managed aggressively and accomplished quickly. At the same time, court fees are financializing the legal system. They're inserting market logics and market processes into our legal system. And these are the legal systems that process foreclosure claims. Chronic underfunding makes courts across the country dependent on fee revenue. As foreclosures rise, foreclosure generates more fees, and these become a critical income stream. In Cook County, Illinois, the research site, foreclosure attorneys directly threaten the court's revenue stream to demand foreclosure be sped up. Together, mortgage securitization and court fees incentivize loan managers and foreclosure attorneys to foreclose on struggling borrowers more frequently and allows them to do it profitably as long as it's accomplished quickly, right? So that's the big picture. That's where we're going. I'm going to spend the rest of the talk proving and discussing these claims. This graph right here, these are financial assets, financial sector assets as a share of US GDP, starts out a little bit above 100% of US GDP, and that's in the 90s, And by the 2000s, it's up in the 400 or 500% of GDP. So financialization is this huge process. It dramatically increases the growth of this sector and their power, right? Its financialization is also part of the great risk shift, which moved risk from businesses and governments onto individuals and markets beginning in the early 80s. It's widely seen as increasing risk and precarity in society, but this relationship is studied mostly through its effect on employment and earnings. Financialization of the corporate sector is associated with reduced employment stability and increased income inequalities. Stock price and financial investment takes precedence over the production of goods and services. Workers are marginalized. Financialization's impact on foreclosure and other debt collection practices hasn't been researched before. There's good reason to suspect that a relationship exists. Credit markets require the forcible collection of debt to function. Creditors use debt collection strategies to enhance profitability and mediate risk. It's integrated into business strategies. If financialization has increased the power of market actors and market logics in society, we can expect that it's affected mortgage foreclosure and other types of debt collection. So now we're going to move on to these specific mechanisms of financialization. So mortgage securitization is the process of bundling hundreds or thousands of individual loans into tradable financial commodities, and it's a key technology of financialization. Securitization replaced local portfolio lending, locally embedded lending, as the dominant housing credit model after the savings and loan crisis of the late 80s and early 90s. To invest in an individual mortgage loan, you need granular information. What kind of neighborhood is it? What are the schools like? Is the house in good shape? Is the foundation shot? Are the walls full of mold? Does the borrower have a job? But if you're buying a package of 1,000 mortgages where borrowers meet certain credit score requirements, the houses are of such and such a value, they're diversified across housing markets, you can achieve a more stable result. The financial engineering behind mortgage securitization is a lot like a sampling methodology. Larger sample size reduces variance. If you have a sample size of 1, you're going to have enormous variance. If you have a sample size of 1,000, you have a better chance of achieving something like the population mean, or at least getting closer to it. And it's the same with mortgages. Buy a lot of them, you have a better chance of achieving the mean housing market return. Economists have found that securitized mortgages enter foreclosure more frequently than non-securitized mortgages, but they don't explore mechanisms or processes. Sociological research on securitization has focused on the production of securities, but not on how foreclosure is organized. Once again, foreclosure is being treated as more or less a straight line outcome from default, with maybe a cost-benefit analysis along the way. I am going to trace how securitization changed relationships between creditors, borrowers, and judges, and examine how this changed mortgage foreclosure. And this graph is just the basic structure of a mortgage-backed security, right? This is what financialization produces. You've got all these different mortgages, pull their money into a pool, and they're distributed to investors. The money is distributed to investors at different risk preferences. That's a basic structure. And it's not really important, so if you're confused, don't worry about it. Court fees. So court fees are another instance of financialization. They're an instance of coercive financialization, right? You have to participate in this. Since the 80s, courts have increasingly applied market logics to legal processes by charging defendants fees for consuming government services, for services rendered. This changes how courts function. Most famously in Ferguson, Missouri, the local court system was designed to maximize revenue, and the whole city budget depended on this money. This led to widespread abuses. It's hardly a unique instance. Municipal court systems across the country have become increasingly dependent on fee revenue. But for people who can't afford to pay their fees, they are effectively forced to purchase their freedom on layaway. So their citizenship, their freedom is financialized. This is coercive financialization. The debts created by court fees extend legal entanglements and destabilize employment and families. They also destabilize housing. They churn people between the justice system, housing hardship, and homelessness. We've never examined the effect of court fees on defendants in civil debt collection litigation of any kind. But this is one of the largest areas of activity and regularly represents more than 10% of all US court cases. And again, mortgage foreclosure has been a major source of precarity in recent American history. So it makes sense to explore this mechanism of financialization, court fees, that we know causes precarity in other areas of the law. How does it affect mortgage foreclosure litigation? And foreclosure is a dynamic social process and should be studied as such. But we don't study it that way, right? We don't study it as a social process. we don't study it as something that emerges from social relations, but it does, right? It emerges from social relations, and as those relations change, we should expect foreclosure to change. So this graphic up on your screen, this is the timeline of a foreclosure in Illinois. You can see they have about 12 months, and this multi-step process with lots of judicial hearings, lots of moments, right? America loves homeowners, and our laws give mortgage borrowers protections that other types of debtors don't have. Renters in Illinois can enter eviction in 5 days after they miss a payment. They usually get a single court hearing, after which they get 7 to 14 days to find a new home or face forcible eviction. Homeowners don't even face foreclosure until they've missed about 3 months of payments. In Illinois, they can stay in their homes for a minimum of 7 months during foreclosure, usually for a year. And they can do that without paying any extra money. They're in foreclosure. They don't have to make their mortgage payment. They still get this time. This creates a free rent period that acts as a social safety net. People use the money they save on housing to pay down other kinds of debt and to find new jobs or find a new place to live. It provides stability for families and children during a very stressful time. It functions similarly to unemployment benefits. The longer the benefits last, the better off people are. However, this creates cost for creditors, and they're highly contested. And we'll discuss what those costs are and who bears them and how that shifts. But every month that the borrower isn't making a payment is a month that the creditor isn't getting paid. And property values tend to decline every day the property's in foreclosure. This is a major cost for the industry. So the longer the foreclosure process takes, the greater the social safety net for homeowners, and the greater the cost to creditors. If you're wondering whether time in the home significantly affects precarity, ask yourself, what if I had to move next week? How hard would that be? How would that affect my kids? Would I need to take time off of work? What if I had a year to move? How much easier would that be? Methods and data. So I answer my research question by conducting a case study of foreclosure in Cook County. And Cook County is one of the largest housing markets in the US, contains about 1.5% of all housing units. And it's a jurisdiction known for protecting borrowers. A major source of borrower protections is judicial foreclosure. If you want to foreclose, you have to show up in court, you have to file a lawsuit, and you have to prove to a judge that you have the right to foreclose on the borrower. I use these court records to create a population level data set of Cook County foreclosures. I also interviewed judges and court administrators. These were people who were part of formal and informal policy groups. I'm using quantitative analysis simply to measure social phenomena. I use qualitative analysis, process tracing specifically, to generate actor-centered explanations. And a couple of notes. I've reproduced some quotes here without ellipses to make them more readable. You can find the originals in the published article or any writing samples. And I'm using private market securitization to measure the financialization of the mortgage industry. This is securitization done by banks and financial companies rather than government-sponsored entities like Fannie Mae. Local savings and loan mortgage lending, this locally embedded mortgage lending, and these government-sponsored entities like Fannie Mae, those are both federal projects to support middle-class homeownership. But private securitization developed in an era of free market supremacy and is completely unregulated. It also grew very quickly during the period of study. It comes into existence in the 80s and early 90s, and then it grows rapidly. It goes from 2% of mortgage securitization in the early 90s, to 11% in 2001, to more than 40% in 2006. And from here on out, when I use the word securitization, it's going to be a shorthand for this private securitization. If you want to know more about Fannie Mae or other government-sponsored entities, happy to discuss it at the end. Okay, so we're going from locally embedded lending to international mortgage markets. This is a historical view, right? Local lenders kept loans they made as long-term assets. And this is, if you see right here, we've got the images of an entire mortgage value chain internalized into a savings loan. They make money across the whole process, and they're trying to maximize value across the whole process. They also are tied to local communities and work to drive repeat business in those communities. If they sold you a mortgage, they wanted to sign you up for a checking account. If your brother decides to buy a home, they want to capture his business too. For these lenders, foreclosure is expensive relationally and economically. They expected to lose 25% of the value during the loans during a foreclosure, so they'd lose 25%. That meant that any deal they worked out with a borrower that cost less than 25% would be a good deal. And these lenders' foreclosure practices were also informed by their relationship to the community and their reputational concerns. I found articles from mortgage industry trade magazines in the 80s warning lenders against good old boy foreclosure policies that delayed foreclosure because of the borrower's relationships to the community or the lending institution, right? So people were basing their foreclosure policies to some extent on their local reputational concerns and local relationships. Mortgage securitization fractures what had been a vertically integrated business into a series of niche markets and specialized actors. Each loan now has multiple owners whose interests don't necessarily align. For mortgages to be tradable financial commodities, someone has to manage the loans and make sure payments are made. And if you see this line of this flow chart across the top that goes from brokerage to mortgage securities investors, that's what most of the research on securitization pays attention to, the production and creation of mortgage securities, mortgage-backed securities. We're going to take a little detour into mortgage servicing and to mortgage servicing rights. So under securitization, loan management is done by mortgage servicers. And these people, if you look at that image of a mortgage security from before and you see what's circled in red, this is what loan managers manage. They manage the mortgages being paid into a pool, right? They want to manage mortgage payments. They also manage, so they process payments and they manage delinquency and foreclosure. They aren't tied to a specific community. They manage loans all over the country. And in reality, these houses in that image, those are not from the same market. Those are all over the country. Borrowers don't get to select their servicer, and servicers don't see borrowers as customers they want to do repeat business with. Servicers also don't lose 25% of the loan value in foreclosure because they don't own the loan. However, servicers do guarantee borrowers' payments to investors. Every month a borrower misses a payment, the servicer has to make it up. Servicers also make a lot of money on fees. Late fees can make up 10% of revenue, and they don't share this with investors. Once a foreclosure is done and the real estate is sold, they recoup all of those missed payments and accrued fees, and they get this money back before investors get anything. These incentives mean that once a borrower gets behind, servicers can profit, or at least reduce costs, by foreclosing as quickly as possible while assessing as many fees as possible. And again, when they're managing these foreclosures, their interests don't necessarily align with those of investors or homeowners. Does this change foreclosure? Yeah, it changes foreclosure, right? This is a graph of annual foreclosures in Cook County. That's the dotted line. And the black line is the average speed of foreclosure, the number of days it takes to complete a foreclosure, the duration of foreclosure. And there's an enormous increase in the volume of foreclosure, that's the line going up, and a decline in the time it takes to complete one, like foreclosure. So in 1992, we have more than 6,000 foreclosures filed. Takes an average of 388 days to complete. 2006, 22,000 foreclosures filed, only 307 days to complete. What are the mechanisms driving that change? Part of it is this new actors in the legal services industry and new demand for specialized legal services. Traditionally, local lenders employed generalist real estate law firms to manage mortgage foreclosures. These lawyers worked with banks and borrowers across many different stages of the life's loan and didn't maximize foreclosure efficiency. They didn't just do foreclosure, they had other types of business. In the early 80s, one real estate attorney who handled foreclosures for a local bank described her experience in the early 80s. We always wanted to work things out. If a client came to me and said, I can't afford these payments right now, can we renegotiate? I would have called up Sam at the bank and said, the Smiths are in my office. Can they, for the next 6 months, pay half? And then when their tax refund comes, can they get caught up? We would just work it out because that was the bank's business. So servicers managing loans across the country don't need legal services for making loans or real estate disputes. They only need foreclosure, basically. And they need foreclosure to be as quick and cheap as possible. Law firms competing for this business worked on flat fee contracts and competed on speed. Instead of billing by the hour, they charged a flat rate, maybe $500, $1,000 per foreclosure. This meant that the faster the foreclosure was processed, the less work they had to do on it, the more profitable it would be for the law firm, the cheaper it would be for the servicer. In the mid-1980s, something called the critical date system developed. This broke foreclosure down into a series of steps and assigned a timeline to each step. Firms that didn't meet these metrics would be penalized. By the early 2000s, there was little discretion left for foreclosure attorneys, even to pursue options that might have avoided foreclosure or saved homeowners and investors money. One attorney described why he gave up his high-volume foreclosure practice in 2001. Servicers used to send me a report every month saying, you met our critical date filing for 87% of your cases, but in the other 13% you failed. As a result, this coming month, we're sending you 13% less cases. I would pull out those cases and write a reply. The Adams case was filed in 36 days because we couldn't get a document from your office. The cause for the delay wasn't sourced from us, so you shouldn't hold that against me. Mr. and Mrs. Banks reinstated their loan on the 34th day. Had we filed on the 30th day, they wouldn't have been able to reinstate because they would have had $900 in additional court costs. We solved the problem. I produced these long letters, and I'd get a letter back thanking me for my effort, thanking me for my insight, but advising me that this month, as in the future, the critical date system would control. For servicers and high volume attorneys, foreclosing as quickly as possible was a way to make money and be competitive in a bare knuckle market. But securitization caused problems that these attorneys needed to solve. Documentation practices in the industry were extremely shoddy. These new operators had no intention of keeping the loan and often neglected the paperwork that was necessary to document the transfers across those securitization chains. So as the loan changes ownership, they don't always dot all the I's and cross all the T's. They might even do a little bit worse than that. According to one long-term practitioner, nobody looks at the paperwork unless you go into default. People were buying hundreds of thousands of loans. Each one was recorded separately, and each one needed to be assigned separately. Try to get a banker to sign 60,000 documents. You can do it, but it's pretty hard. Paperwork was regularly lost, and even when it did exist, it might be impossible to locate quickly. Flawed or lost documentation called into question the plaintiff's right to foreclose and slowed down the process. It was a problem that had to be solved. And this problem is, how are you going to prove your case about payment histories and original documents? Had to be solved. One answer was affidavit fraud. Affidavits are sworn statements that serve as a stand-in for courtroom testimony. They are common in legal proceedings and became a primary form of evidence in foreclosure cases across the country. Lawyers and judges recall regularly encountering flawed or fraudulent affidavits in the early 2000s, and by the mid-2000s, it was an everyday occurrence. One firm for filing false affidavits in thousands of cases. This firm basically kept a pile of pre-signed signature pages for their clients and would just staple them to whatever they needed to prove. This is an attorney who works in the industry describing the process. And it was very funny to me because even though this firm had a history of similar abuses and was caught in this case with about 2,000 mortgages, he described it as a one-time thing that was just a shortcut. And they were good guys, but this is how he described it. They do an affidavit and they would take the signature page and alter it. Our attorney's fees were $1,000, but they went up to $1,250. So we're just going to change the affidavit. I don't think they were doing anything that was wrong. And I don't think the information was wrong, but it's just not how you do it. But if I sign an affidavit, nobody better touch it because you're liable for penalties of perjury, all sorts of things. Lawyers and judges recalled many cases where affidavits were challenged and the person whose signature appeared on the bottom of the page didn't know anything about what they'd supposedly sworn to. This was not considered fraud by judges, but was considered problematic. When judges caught this, they seemed to generally only require the attorney to refile the document, the affidavit, without the irregularities. Judges described these problems as the result of lawyers being overworked or too busy, and seem to discount the fact that this is outright fraud. So how is securitization related to these population level changes in the Cook County foreclosure I mentioned earlier? Again, annual foreclosures are going from about 6,000 in 1992 to about 22,000 in 2006. It increases more than 250%. During the same time, this private label servicing outstanding. Private label servicing outstanding is the dollar value of mortgages packaged into these private market mortgage-backed securities. So it's the dollar value of currently, at this moment, mortgages in private mortgage-backed securities. The total dollar value, it increased by over 130% during this time span. At the population level, annual foreclosures and this PLS servicing outstanding, they're correlated at about 0.92. And this, for what it's worth, this correlation is significant at the 99% confidence level. So there's strong evidence that these two things are associated, right? They at least head in the same direction. Over the same period, the duration of foreclosure, the amount it takes to complete a foreclosure, the speed is decreased by more than 20%. So foreclosure gets about 20% faster. This reduction saves servicers about 3 months of mortgage payments and costs homeowners 3 months of free housing. And if that doesn't seem like a lot, annual foreclosure filings in Cook County, again, grow from 6,000 in 1992 to 22,000 in 2006. Correlation between logged PLS securitization outstanding and the duration of foreclosure is negative 0.86. And again, the correlation is significant in the 99% confidence level. So we have at least a statistical relationship between the kind of the kind of mortgage securitization that is most associated with financialization, an increase in foreclosures, and a decrease in foreclosure speed. But there were other problems that attorneys had to solve. One of them was the judiciary's unwillingness to spend more time and resources on foreclosure. Just because foreclosure filings were growing didn't mean chancery judges were going to hear more cases. Chancery judges traditionally started the day with a handful of foreclosure hearings before moving on to what they considered the real work: complex litigation, class action, state constitutional issues. This made it difficult for foreclosure attorneys to meet their deadlines and force servicers to make additional mortgage payments. This is a problem. One attorney described how Cook County judges dealt with the rising tide of foreclosure. If you wanted to have a foreclosure motion, there was a book, and you'd write in it by hand. In the 90s, some of the judges got pissed off, and they cut the book in half. They'd say, "I'm only hearing 10 motions a day." That's how crazy it was. Now, chancery judges were very powerful, and they handled very different kinds of cases, but foreclosure was boring. So as foreclosures rise, though, the amount of revenue the court collects on them also grows. And by the early 2000s, the entire county court system had become quite dependent on the fees the foreclosure litigation generated. And if you see the two columns highlighted, the first column is foreclosure as a percent of appropriations, foreclosure fees. So that's how much money they made as a percent of their total funding. And that's growing pretty consistently from 2% in 1993 to 5% in 2005. And the second column is foreclosure as a total percent of fees. So that's how much foreclosure fees grow as a portion of total fee revenue. And that's growing from 2% to 8%. And it's steady growth, right? It's growing pretty steadily. So since at least the since at least the early 90s, state and county funding had failed to adequately support the court. Foreclosure revenue had grown consistently for the same period of time. And these fees don't just fund day-to-day operations. They pay for children's waiting rooms. They pay for roadside memorials, drug diversion programs, law libraries, document management technology. And I don't think the judges were aware of how dependent they had become on foreclosure litigation fees, but the mortgage industry definitely was. In 2001, a group of high-volume foreclosure attorneys met with the Chancery's new presiding judge and issued a threat. Either foreclosure processing time would be reduced, or they would take their cases and their fees to federal court. One of the judges involved in the effort confirmed the presiding judge's account. The mortgagee's bar was exasperated by the length of time it was taking. "We were exploring the federal court. The presiding judge definitely heard from the foreclosure firms, 'Hey, we're looking at maybe moving foreclosure to federal court, and that's going to have a big effect on what the filing fees are.'" Now, foreclosure attorneys and mortgage lenders have been complaining about the Illinois foreclosure process, Cook County foreclosure process, since literally the 1850s. There's articles in the, ancient predecessors of the New York Times complaining that, nobody can make a mortgage loan in Illinois or Cook County because the foreclosure is just too slow and too expensive. And there were huge lobbying efforts that did bring some kind of changes to foreclosure. As recently as 1987, there were changes in statute, how the statute that governed foreclosure. And in 1987, they got foreclosure shortened and kind of rationalized, according to proponents. But they only gained leverage over judicial procedure once the court became dependent on the fees they brought in. That was new. That was different. They hadn't previously been able to get leverage over the court. So faced with the prospect of losing critical revenue, the Chancery judges found a solution. A pilot project was implemented to create a new subsection of the court that would handle foreclosure, and new judges were appointed to it. The new subsection began hearing cases on October 1st, 2002, and was made permanent in 2005. One of the new judges described his role in the pilot project. "There was a backlog. They weren't moving foreclosure cases fast enough. I had already developed a reputation for being efficient at moving high-volume courtrooms. I didn't know anything about foreclosure. I never practiced in real estate. I said, okay, I reviewed the statute, and I got ready." The results of the pilot project. The pilot project did, in fact, reduce the amount of time it took to process foreclosure by almost 50 days. We have a reduction from about 360 days before the pilot project, that's the average duration of foreclosure, to 311 days, 310 days, let's say, after the pilot project. Statistically significant, beyond the 99% confidence level. And it's population data. So this really did change something, right? And it really did speed up foreclosure. Coincidentally, perhaps, the court would hike filing fees the same year. The pilot project was launched in October of 2002, and the fees went up $51 in December of that year. From $220, this is the largest fee increase observed during the period of study, the second largest fee increase observed is a $5 raise in 1994 from $215 to $220. So this entire time, fees are pretty stable, and they're much cheaper. But this is a change foreclosure procedure to protect fee revenue, and then they raise fees. So let's get to the conclusions, right? Through securitization, financialization restructured the mortgage industry so that parties managing delinquency and foreclosure lacked significant investment in loan outcomes, repeat customer relationships, or local real estate markets. Over the period of study, foreclosure is sped up by almost 3 months. This occurs while annual foreclosures increase by more than 250%. For servicers, securitization meant that foreclosure could be profitable if properly managed. Reducing the duration of foreclosure, speeding up foreclosure, was key to that profitability for both servicers and the specialized foreclosure attorneys they employed. At least some of these law firms relied on strategies like false affidavits to fix documentation problems introduced by securitization. The foreclosure practices that increased the frequency and speed of foreclosure were integral to the financialization of the mortgage market. They were solutions to problems created by securitization, and they became possible because securitization changed incentives and relationships within the mortgage industry. Without the innovation of widespread evidence fabrication, securitization's documentation problems may have rendered mass foreclosure either prohibitively expensive or legally impossible, either of which would have posed a significant challenge to the business model. Foreclosure attorneys were also able to leverage the court's budget pressures and fee dependence to affect how judges managed foreclosure. Judges in Cook County developed the capacity for efficient mass foreclosure, for processing more foreclosures more quickly, in order to retain foreclosure-related revenue. The pilot project was a success that allowed the chancery judges to offload low-status work while satisfying the mortgage industry and retaining foreclosure. It's a win-win, except for distressed borrowers. Pilot project reduced the average duration of foreclosure and the free rent period by about 50 days, right? So we see financialization creating both incentives and possibility to speed up foreclosure and being directly involved in 2 mechanisms, mortgage securitization and court fees, that directly speed up foreclosure. Now, where do we take this work? What happens next? So other types of non-foreclosure debt collection can be theorized as social processes related to financialization, market structure, and precarity. Our economy depends on credit, but many of us can't pay back what we owe. Millions of Americans are sued by debt collectors every year. Millions of Americans live paycheck to paycheck and cannot afford emergency expenses. This means that debt collection processes like mortgage foreclosure or wage garnishment are mechanisms that directly create precarity. If we care about equity or well-being or other outcomes, we should care about how states enforce debts. I've focused on an area where borrowers have significant protections. This is an extreme case, right? They have significant protections that are denied to other borrowers. But where these protections are less, we might expect financialization to have a larger impact on collection strategies and a larger impact on precarity. There's been a great deal of research, so we definitely should be looking at this in other areas. This is not just, I would be highly surprised if this is just a dynamic in mortgages, right? There's been a great deal of research on the racialization of predatory lending, but we've not examined racialization within the foreclosure process. As one of my interview subjects told me, no one complains when you give them the money. They complain when you take it back. By examining the harm of racialization only at the moment of lending, we ignore potentially significant mechanisms of racialized housing inequality. We need to ask ourselves how collections practices are racialized and how they contribute to racialized housing wealth. This research also raises new questions about how states manage and enable markets. Most research on this issue focuses on national actors. The findings here suggest that judges play a significant role in shaping markets at a local level. And something I didn't discuss earlier was that the efforts to leverage court fees were, according to participants, made in courts around the country. I'm currently in the process of trying to confirm this and measure those effects, but it's definitely an area where I am paying attention. So this is not necessarily just a Cook County story, right? This is something that, according to people who were participated, happened around the country. And this is also something we can expect to show up in other places. That's all. Thank you so much for having me. And I will take any questions if there are any. Let me just figure out how to stop my screen share.
Thank you so much, Walker. If you have questions, feel free to just either unmute and ask a question or put it in the chat. We wait to see if there are questions from others. I have one to start, which is that it was fascinating that you were looking at the period up to the crisis that occurred.
Mm-hmm.
You have a sense at this point about what caused it to slow down and whether it's building again, whether sort of, yeah, have these issues been resolved, or is it a waiting period? Do you have
No,
any
the
sense
issues
of
have
that?
not been resolved. The issues have been unfortunately normalized and standardized in a lot of ways. There were a lot of efforts to normalize procedure and legitimize procedure that didn't exactly attend to the underlying problems. So in Cook County, for example, the judges are very proud. And they took, so first, once the foreclosure crisis became a national crisis, once it was conceived of as a crisis and not just a bunch of deadbeats missing their loans, which is what it had been conceived of before, right? They took action. They created, in Cook County, they created a mandatory mediation program. You had to mediate, which gave everybody an additional 6 months minimum of a free housing period. However, they were not about to start really interrogating foreclosure documentation or foreclosure practices. And from the perspective of somebody trained as a lawyer, that makes a lot of sense. It might seem insane to us to understand that there's a false evidence problem and just have the judges kind of ignore it. But US law works on an adversarial system, right? It is not the judge's place, really, it's not the judge's place to launch an investigation into the plaintiff's documentation. That is the duty and the role of the defendant. If the defendant doesn't have a lawyer, it gets kind of tricky. But judges very much felt conflicted between this role they had as a neutral arbitrator who was not doing any kind of fact-finding or investigation, and documentation they were handed regularly that was clearly not up to par, that was clearly not legitimate, right? That was a moral conflict the judiciary was having. And they solved that by giving people more time in their homes, not so much by clearing up those underlying issues. And it's something similar to what our federal government did. Our federal government in the US, we replaced the kind of the bright line rule of law with statistical thresholds, right? So the national mortgage settlement of 2012, I think it got finalized, it was negotiated for a while. We set a threshold of, for the biggest servicers, a self-reported threshold of 1% for improper foreclosure. So as long as you, as the servicers, didn't improperly foreclose on more than 1% of all of their foreclosures, the attorney generals of the states and the US Department of Justice would not investigate, would not do anything, as long as they kept it below that threshold, right? And they did that for all sorts of things. That was true for mortgage payments too. In the national mortgage settlement, the banking industry, the servicing industry, got the right to misrecord borrowers' payments. So there's a problem that you would pay your mortgage and they would record the wrong number. They would misrecord your payment, right? This is a huge problem because it generates late fees and it's theft. It's literally stealing. And the U.S. government created set a threshold that as long as you don't misrecord the payment by the greater of $50 or 3%, 5% of the time. So you have a 5%, you can misrecord payments 5% of the time by no more than, you can misrecord payments by more than $50 or more than 3% of the payment. You can do that 5% of the time, but if you do it any more, you're in trouble, right? And that can trigger late fees. It can trigger all sorts of things. But no, we have not solved this. This is an ongoing crisis. And if anything, we are only more dependent on credit as a consumer economy. I only see us getting more dependent on credit. And there is still a real disinterest in getting to the root of this or enforcing debtors' rights in a meaningful way. And this is, again, made more complicated by the fact that people who can't pay their bills don't have lawyers. And we assume that people do. The American justice system assumes that this is kind of an adversarial event between two equal parties. And while we have guarantees for lawyers for criminal defendants, we have no such thing for civil defendants. So people are just on their own.